Hello, this is Kentucky Equal Justice Center, and we're sharing information about employment rights, kind of know your rights information for workers in the workplace. My name is Miranda Brown. I'm our outreach coordinator, and I help coordinate our wage claim clinic in Lexington. Why don't you introduce yourself?
Yeah, my name is Mackenzie Cantrell. I am Kentucky Equal Justice Center's employment law attorney, and I'll tell you a little bit more about what I do when I tell you a little bit more about what the employment law project at KEJC does.
Okay, so I'm going to share our presentation with you all. Cool. Okay, did I share the right one?
Looks like it.
Okay, good. So we've already introduced ourselves. So Kentucky Equal Justice Center, we are a statewide organization that was formed in 1976 as an administrative and lobbying arm of the civil legal aid programs. We still have ties to legal aid, and legal aid is for organizations in Kentucky who serve people with civil legal issues, not criminal, and they are free. It's free legal services. So we still have ties to those programs, but we perform work that the legal aid programs may not be able to perform due to their funding restrictions. And we have 6 attorneys on staff currently who specialize in different areas and advocate for policy changes in Frankfort.
So I'm going to break it down a little bit more and tell you specifically what KEJC's employment law project or workers' rights project does. We take that bigger picture idea of plugging in what the legal aid community cannot do, in that legal aid attorneys do not necessarily get involved in employment law matters. So we provide the services on employment law that we provide sort of in 3 different ways. We do presentations like this, right, which is part of our education model. Miranda and I both can do those presentations in English and Spanish. We can do those around the state. If you have an organization that has clients that you think might be amenable to this type of information, we can certainly talk to you more about delivering a specialized presentation for your group. Obviously, I'm an attorney, and we litigate in court employment law cases. We mostly specialize in what's called wage and hour or minimum wage and overtime violations, breach of contract. If it wasn't maybe an hourly job, but someone said, oh, I'll do this job for you in exchange for $5,000, that's not really an hourly job. That was more of a contract job. And we also specialize in human trafficking litigations. We take the litigation and information from the community that we provide and that we interact with a lot of people, and we use that information to advocate for workers across the state. We do that at the federal, state, and local level on all types of different kinds of topics. And, specifically, I'll give you an example today that we're doing. I'm filing some comments for a proposed regulations change at the federal level. And I might talk about that a little bit later on, but that's just an example of how we advocate for workers across the state. I'm a lawyer, so there's always got to be a little bit of a disclaimer. This is a general presentation. I would not take this presentation and start to give legal advice or anything like that. My name and phone number is on this slide if you want to take it down. Even though I'm working remotely because of the pandemic, or a lot of people in our office still are, this phone number forwards to my cell phone. People can still get a hold of me, and it's better off for someone who has a unique situation. I want to give you all some tools to give some advice and to recognize a problem when you see one, but when you recognize a problem, that might be time to pass it off to another entity. We'll talk about what those other entities might be later on in the presentation, or you could just call me and have your client or your the person you're providing services to be able to speak to an attorney directly.
Okay, so first off, we're going to talk about health and safety in the workplace, and then we're going to get into wage and hour and rights after termination and some other issues. But we want to talk about topics that are important to workers generally, but also during this specific time. So we're looking at not only health and safety generally, but also regarding COVID. So generally, it's ultimately the employer's responsibility to maintain a safe workplace. Falls are the most common workplace injury, and employers should encourage employees to report unsafe working conditions. A safe, clean working environment also improves productivity, so it's good for the employer as well as the employees. And workers should have access to workers' compensation if they're injured on the job. Now, specifically during COVID-19, the Occupational Safety and Health Administration, the federal agency, and the Centers for Disease Control and Prevention have published voluntary guidance, which has been updated during the pandemic for employers to protect workers from COVID-19 transmission. And looking at some updated points in that guidance, we've just listed a few here. They've encouraged employers to engage workers in every step of the COVID-19 prevention program. They're still encouraging physical distancing between people to 6 feet, and that people wear masks, and that there be flexibility in where and when workers do their job. That workers should still be washing hands frequently and limiting the use of shared spaces and cleaning and disinfecting, and that there should be flexible sick leave policies, so that workers should be encouraged to take time off when they are sick. And of course, there's special guidance for healthcare workers.
So I'll point out that we are recording this, it's May 24th, and you might not see this presentation for another couple weeks, but we wanted to give you the most up-to-date information. And so we're giving you the most up-to-date information we can, with the caveat that we're recording it on May 24th, because this information is changing all of the time. So as you all know, the mask wearing and the rules around mask wearing has changed quite a bit, and that can affect someone's situation in the workplace as well. So we had a mask mandate that was renewed for several months in a row. And now that the CDC guidance for vaccinated persons wearing masks indoors has changed, the state and local rules around mask wearing has also changed, with some caveats. So most people think, everything is being lifted as of June 11th. What it actually says is, in an educational setting, in a healthcare setting, long-term care, correctional facilities, homeless shelters, and different individual situations, you may still have to wear a mask. And that could apply to someone, because one of these exceptions could be someone's workplace. And in the workplace situation, that employee would also be required to wear a mask and still comply with the most recent CDC recommendations and executive orders from the governor. So as that changes, you want to keep people up to date about that. That's the most recent guidance that we have. This is just sort of a general rule that employers have their own employment policies that employees are mandated to follow, and they know that they need to follow in certain situations. A lot of employers have changed their guidance and rules and policies and updated a lot of that, and then made that known to their employees as we've gone along, and are following the most recent public health guidance in relation to the virus. Every industry is different, every workplace is different, and so a lot of those recommendations and a lot of those policies are different as well. But employers, when they're enforcing policy, need to enforce their policies uniformly. They're legally required to enforce policies uniformly, because if they don't, they become susceptible to claims of discrimination, retaliation, and other things that we're going to talk about a little bit more during this presentation. But as long as employers uniformly enforce their existing safety and health policies and are following industry guidance or any OSHA guidance that comes out, we'll talk about OSHA guidance in just a moment, then as long as they're enforcing their existing policy to keep their workplace safe and healthy, then employees also need to follow that guidance as it's being enforced uniformly. So the other big thing besides mask wearing that is a constant shift is our trend locally about vaccinations in Kentucky. So I looked at the numbers today, and as of the time that we're making this recording right now, 37.4% of Kentucky residents are vaccinated. So the question in employment law becomes, can an employer require an employee to receive a COVID-19 vaccination? You know, everyone has a different opinion on what type of vaccination they want, when they feel comfortable receiving it, and what that means for their own health and safety, their family's health and safety, and then they're safe and healthy in the workplace. The Equal Employment Opportunity Commission has recently put out some guidance on answering that question of whether an employer can require its employees to be vaccinated. We've sort of seen some stories in the news about whether it's universities or other workplaces that are starting to develop policies that are going to mandate some level of vaccination. And we've also seen some people who've already had some negative employment outcomes because they refused to get a vaccination and wanted to continue with that employer. So here's the most recent guidance. You can find the full guidance on the EEOC website. They have a lot of coronavirus resources available. So an employer may encourage or even require the COVID-19 vaccination. But if you do that, your policies have to comply with federal law, right? Existing federal law covers a lot of these situations. You can't discriminate based on someone's, we're going to talk about maybe religion here in a moment, or their disability, and someone's religious beliefs or their disability could come into play when you talk about their vaccine status. So this is the heart of the EEOC guidance right here. If a vaccination requirement is going to affect a worker with a disability, the employer must show that an unvaccinated person would pose a direct threat to a workplace, right? That's kind of a high threshold. And there'd have to be a significant risk of substantial harm to the health and safety of other individuals or other individuals within the workplace or other employees within the workplace that can't be eliminated or reduced by reasonable accommodation, right? We know that that term, reasonable accommodation, is already sort of the standard in disability law, that if someone has a disability, they need to be able to do their job, but if they can do their job with a reasonable accommodation, then the employer needs to provide it, right? That's using the same standard that we are accustomed to and applying it to vaccinations. So there's some factors that the EEOC has put out saying, well, what does a direct threat mean? It means, you know, how long would an unvaccinated person be exposed to the public? What does that mean for what would the severity of the potential harm be, the likelihood, and how imminent would potential harm be? So again, that does not relieve the employer of the ability or the necessity of providing a reasonable accommodation. The slide gives some examples here that a reasonable accommodation could be working remotely or taking a leave of absence. I read some examples in preparing for today's presentation about religious accommodations. That was a really interesting one, that if someone's religion indicates that they might be not wanting to get the vaccine, then basically the reasonable accommodation that is left is this working remotely, taking a leave of absence, reevaluating, because that would be a type of discrimination. So you got two different types of discrimination. Disability would be under the Americans with Disabilities Act, and then discrimination for reasons of race, gender, national origin, religion, and all those typical protected classes. A violation of a vaccine policy for discriminatory reasons would be under federal law, Title VII, and state law, the Kentucky Civil Rights Act. So vaccines are here. People are definitely taking advantage of them, but employers and how they affect employees and how future policies are going to be adopted around vaccines, people really need to be paying attention to that. So moving beyond that, I wanted to provide you all with, Miranda talked about just some general safety and health tips in the workplace. And she mentioned that OSHA guidance up until now has pretty much been voluntary. And that was, we've had a change in administrations at the federal level. And that was a big criticism in the employment law world of the Trump administration, was that the administration never really even considered adopting and never adopted what are called standards during COVID-19. So a standard is basically the law. OSHA is an administrative arm of the executive branch of government. The rules that they adopt and put into place are mandatory. They're not laws as in adopted by Congress, but administrative law in this area, and making those really flexible decisions and adjustments are mostly what employers are bound to when we talk about safety standards. So just think about standards as being mandatory, and then that guidance that Miranda alluded to earlier is voluntary. So when President Biden took office, right after he took office, January 21st, he issued an executive order directing OSHA to revise its guidance and consider adopting some of those standards. Based on some news reports that I read from the past few days, the White House was actually in its final stages, like within days, of finalizing some COVID-19 workplace safety rules that would, again, be standards and not guidance. It's taken a long time for the White House to do this because of the complexity of creating guidance for a lot of different workplaces. Especially if you heard our presentation last year, or you've heard Miranda and I speak in other contexts, we have an employment law podcast that you can listen to. You'll know that workplaces are very different, and creating something that's going to accommodate a lot of different workplaces and keep people safe in the same way is a very, very difficult thing to do. And so now you see that the White House was pretty close to doing all that, and then the CDC made a lot of changes to the mask guidelines within the past couple weeks. And a lot of people were thinking that any employer guidance was going to require masks within the workplace. So you might still see them tweaking a little bit more even before you see any OSHA standards released that apply to workplaces. So keep track on that. This is definitely a changing area. We all know the guidance changes every day. It's hard to keep up with, and that's true in the workplace as well.
So in the workplace, when issues come up, whether it's COVID or something else, workers definitely need a way to report those problems. So for COVID, workers can call the KY Safer tip line. And this is still an active line, even though things have maybe simmered down some at this point. But you can still call and report violations to COVID-19 restrictions at this phone number. And then in general, so you can report COVID issues to the Kentucky Occupational Safety and Health, or to the federal US OSHA. And then, so whether it's COVID-19 or some other aspect of the workplace that's a hazard to someone's health, or workplaces aren't being provided with appropriate protection equipment, whatever it is. This link and this screenshot shows you where you can go in Kentucky to file safety and health complaints with Kentucky OSHA and the federal OSHA. So there are several complaint forms there, and complaints to the federal OSHA will be directed to Kentucky.
Thanks, Brenda. So when we talk about the KY Safer tip line to report violations of COVID-19 restrictions, that's that's more of a temporary safety and health place for workers and members of the public to go to get some advice or potentially report on a bad actor. The second part of that slide, the Labor Cabinet online complaint form, is the general way any worker can report any hazard in the workplace. You can do it online, you can do it anonymously if you need to. So that's a very important resource. Again, the first one is a temporary COVID-19. The second one is what you would give to anyone at any time who needed protection in the workplace and to report unsafe working conditions. So we talk about that, and then to follow up with the law around retaliation, it is illegal to fire someone because they filed a complaint regarding discrimination in the workplace. Usually in this presentation, we talk a lot about what discrimination is and isn't. We wanted to focus again on these COVID-19 related safety and health guidelines, because that's probably what you're going to be receiving a lot of questions from that touch on employment law in the immediate future. But again, a lot of these traditional rules about discrimination, about people with disabilities, about retaliation, they all apply in the COVID-19 context. And they may just apply a little bit differently. I think you'll see that a little bit, especially when we start talking about unemployment. It's illegal to fire someone because he or she complained about a safety issue in the workplace, or that they filed a workers' compensation claim. That's very important to note, that you do have some legal protections there. You should always tell people who are dealing with issues in the workplace that writing everything down and whether it's keeping a journal, keeping a diary, keeping track of all the hours that they're working is very, very important. If someone comes and sees me as an attorney, that's the first thing I'm going to want to know is what's been going on. And if someone has a long history of issues in the workplace, the easiest way to provide someone like me with that information is to have it sort of detailed already. Federal law can also protect workers who engage in safety and health activities, because it could be protected under the National Labor Relations Act, which gives protections to workers for joining together and fighting for better work conditions. If the action engaged in by the employee was to protect others in the workplace, it could be protected under the National Labor Relations Act. So again, you have a lot of state and federal laws working sometimes together, sometimes a little bit of tension, which I'm going to talk about a little bit later, where you might have some different guidance. But for retaliation, just keep in mind that someone who complains about a safety and health, discrimination, or other lawfully protected activity in the workplace, then it would be illegal for them to be fired, demoted, paid less, to have their work schedule significantly changed could even be an indicator of retaliation. So just keep that in mind as we go through more of this presentation, that you're not just protected in sort of the underlying activity being free from discrimination or safe and healthy in the workplace, but complaining about it also could give you some additional protections. So we're going to move into some wage and hour and overtime. Some of this will be updates. Some of this will be information that you're probably very familiar with. So we'll start sort of at the beginning. Kentucky follows the federal minimum wage, which is currently $7.25 an hour. Employees must be paid at least the wage that was promised to them, right? If someone is promised $10 an hour, that could be a contractual situation. And it also means that if someone gave up the opportunity to make a different amount of money, but they chose to work for this particular employer who promised to pay them a particular amount of money, then the fact that they gave something up and gave up other work to choose to work for this employer creates a contractual relationship that employees must be paid the wage that was promised to them. Immigration status is not necessarily an issue for the promise to pay. I know a lot of workers, especially who are here without legal documentation or citizenship status, have questions about this because a lot of people use this as a way to threaten our immigrant population and say, well, I could just call, immigration on you, so I don't have to pay you. And pairing that, not only am I not going to pay you with a threat, is a very real and scary thing for our immigrant population. But the law does not look at it that way. The law looks at it as everyone deserves to be paid this amount. Especially they deserve to be paid for what they signed up for, and that a lot of our agencies, our state and federal agencies that you can report violations of wage and hour law to, also have protections for immigrants, that they don't turn that information over to another entity, for example. Our tipped minimum wage is $2.13 an hour. So if you have a client who works for an entity that receives a certain portion of their pay in tips, their employer can pay them as low as $2.13 per hour. They still have to earn the $7.25 per hour, but the way they do it is different because the employer pays that amount, and then the customer is, the way it's set up is the customer is supposed to make up the rest because of the tips that a worker would earn throughout the hour or throughout the day. Mandatory tip pools are illegal in Kentucky. So for restaurant workers, this is particularly important, that if an employer mandates that you pay into a tip pool, or that all workers who are engaged in a tip pool would split tips with a certain percentage, mandating that is illegal. Voluntary tip pools are legal, mandating it is not. You have all different types of people in the restaurant industry. That you have tipped workers, you have hourly workers. So a tipped worker would be a server, for example. An hourly worker would be someone who busses tables, for example. And then a salaried worker could be a back of house culinary worker. So there are certain requirements in order to pay someone a salary, and a lot of them do not apply to the restaurant context, but there are some positions I can think of where a restaurant worker who supervises other kitchen staff, who has culinary training, and again meets that salary threshold where they're paid a minimum amount every week, that could be a sort of legally compliant salaried position. I'm talking a lot about restaurants because I have personally seen a lot of violations of wage and hour law in the restaurant industry And again, I think you can see why is because you have all the different ways you can pay someone, and you have restaurants that are set up to pay all those different people in that different way. We know that if you work more than 40 hours a week, that you are entitled to overtime. Overtime is time and a half for all hours over 40. Of course, if you're a salaried employee and you meet those requirements to pay someone a salary, overtime does not apply to you. That we call that exempt, non-exempt under FLSA law, or the federal the Fair Labor Standards Act, which is the federal minimum wage and overtime law. Kentucky has a couple of little nuances to its minimum wage and overtime law. They have something called 7th day overtime, which I always say is something I hope nobody has to be paid or take advantage of, because it means you're working 7 consecutive days at a time. But again, that 7th day overtime is a requirement under state law. If you've heard Miranda and I speak before, you should know what misclassification is. Misclassification is treating someone as an independent contractor when they should really be an employee. So when someone's treated as an independent contractor, they don't have their taxes taken out for them, and none of the stuff that we've talked about up till now, discrimination, health and safety, wage and hour law, none of that applies to independent contractors, and all of it applies to employees. So some places, some employers will want to treat their workforce as independent contractors because they don't want to be compliant with everything that we've talked about up until now. So misclassification is a big part of wage and hour law. And I wanted to point out a couple of different trends. So our state legislature has actually given a lot more types of professions and types of workers who can be considered independent contractors, right? They've written them into the law. So you have, I think the example is certain types of lawn care workers and certain types of gig economy workers who work on app-based platforms can under certain conditions be required to be independent contractors. And then you have the Biden administration come in, and under federal law has actually removed a previous rule, making it easier for employers to classify their workforce as independent contractors. So you have tension between those recent trends that could make it more difficult for people like me practicing law, but it's just important to know it's important for employees to know the difference, that when they're signing up for something as an independent contractor, that they really are an independent contractor, and they know the consequences of that when they go, if they get hurt on the job, or when they go to pay their taxes, or if they're discriminated against or sexually harassed in the workplace. It's very important to know what your expectations are up front.
So when it comes to workers who are not being paid the wages that Mackenzie discussed on the previous slides, sometimes it's a contractor that should be an employee and should be paid according to employee rules, and they aren't, or someone who just isn't paid what they were promised or not paid minimum wage. This is where Kentucky Equal Justice Center can help. We're not the only place. We'll talk more in the coming slides about where else you can get help with a wage and hour complaint on the federal level or in the state. But we can help with the first step of helping workers file a demand letter to their employer, like sending a demand letter to their employer, stating the Kentucky statutes and stating how much they're owed. And we also help workers file complaints with the Kentucky Labor Cabinet. And so we are, during the pandemic, we've been taking those calls just over the phone and counseling people that way and helping them write their letters. But we are planning to resume in-person wage claim clinics monthly beginning in July. And our tentative dates will be in Lexington, third Wednesdays in the evenings, and in Louisville, first Wednesdays. But stay tuned for confirmation of the Louisville dates. In Lexington, we have it at the Maxwell Street Legal Clinic, which is part of our organization and is located behind the Maxwell Street Presbyterian Church on Lexington Avenue and Maxwell Street. But it is free assistance that we provide, and we encourage people to call to make an appointment, or if they're not comfortable coming in person, we may be able to help them over the phone. So we know that some people want to try doing this on their own, and that they want to try writing a demand letter or filing their complaint on their own. And so we've tried to make that even easier for folks to get advice about how to do that by creating this web app. So by the time you are listening to this or watching this presentation, this link should be live. And it's just kywagetheft.org. Here we have a screenshot of our rough draft of the first page of the app, which gives some basic information about what wage theft is and what the app is for, which is to input, for the worker to use to input their own information and their employer's information in order to generate a demand letter addressed to that employer that the app can send to that employer's email address, or that the worker can print and send themselves to their employer. So again, that link will be kywagetheft.org, and that should be live by the time you're watching this.
Thanks, Miranda. So we've tried to talk about some of the topics that we've discussed in sort of a chronological order. So what happens when someone loses their job and may or may not qualify for unemployment benefits? So the general rule of advice is Kentucky is an at-will employment state. At-will employment means that an employer can terminate an employee for any reason, no reason, a good reason, or a bad reason, as long as it is not an illegal reason. The illegal reasons to fire someone, some of them we've already talked about. When it says contracts here on the slide, that's a written employment contract. A written employment contract changes the standard from at will to for cause. So a written employment contract changes that standard. You cannot be fired for discrimination. That's an illegal reason to fire someone in Kentucky. We talked about Title VII under federal law. We've talked about the Kentucky Civil Rights Act. And we've talked some about the protected classes, gender, race, age over 40, sexual orientation in some counties that have adopted local ordinances in Kentucky, national origin, religion. Think about all those things that we can't change about ourselves. We talked about what retaliation means, that you can't be fired for retaliation. And then if you're a member of a union has what's called a collective bargaining agreement. And the collective bargaining agreement is the agreement between the employees and the union and the employer. And that governs a lot of disciplinary action between the employee and the employer. And because that collective bargaining agreement is a contract, that's what makes the standard different between at will and a union contract. So they sort of have their own process that they follow. So keep that in mind, that union employees are different. If someone is separated from their job and is looking for a new job or is looking at sort of what's next, we talked about employer policies being really important. They're even more important. Can be, even if the employee isn't working there anymore. Keep in mind that employers need to pay any wages owed within 14 days, pay medical, travel, other reimbursements that were used as benefits during the employment. Most of us are familiar with what COBRA is, that an employer must notify an employee that he or she can stay on that employer's healthcare plan for 18 months at that employee's election and cost. Sometimes that can be kind of expensive. So job separation is a qualifying event to shop for marketplace coverage at healthcare.gov or under the state exchange, or the employee might qualify for Medicaid coverage and could enroll in Medicaid during that job separation time. So just keep in mind all of your benefits need to be reviewed when you leave a job.
And we are doing a separate presentation for this summit about public benefits, which goes into more detail about the health coverage options for people who don't have that option through their job.
So a lot, unemployment's been all over the news, right? In Kentucky, a lot of people lost their jobs during the pandemic. Their job has changed substantially, whether their hours were cut. I'm going to give you some basic rules about unemployment, and then we're going to get into a little bit about pandemic unemployment and how it's changed. The regular standard for unemployment is misconduct related to the work, right? You cannot have committed some sort of misconduct and then expect to get UI benefits. If it's mostly like what a lot of people have experienced during the pandemic, being laid off. So sometimes voluntarily leaving your job with good cause attributable to the employer, like discrimination, for example, would be a good reason that someone could still receive unemployment insurance. The employee has to follow a lot of rules. Some of them have been waived during the pandemic. Work search requirements, for example, those are coming back, but those were suspended for a long period of time. And then some of these traditional rules that we're talking about on this slide sort of went out the window during COVID because there were certain types of workers and certain types of individuals who did not typically qualify for unemployment, who are now eligible for unemployment during COVID. So that's our first, when we're talking about pandemic unemployment coverage in this next slide, this is what we're talking about. We're talking about people who are self-employed, independent contractors, freelancers, part-time, and other just types of non-traditional work that you could not normally get UI for. That's PUA. Then you have the PEUC, the Pandemic Emergency Unemployment Compensation. That's that extra amount of time. Those are extended benefits that UI claimants can claim when you could really only claim a certain number of weeks under the state. The federal government stepped in with legislation last year and gave an extra 13 weeks of coverage. The most recent type of federal pandemic unemployment compensation is the FPUC. That's how you say the acronym, and that's an extra $300 per week in federal UI benefits. Now that expired March 14th, but there are still people who we know who have struggled to receive unemployment benefits and are still working to get those. They're calling, they're emailing. I'm definitely seeing those calls and emails. You probably are trying to help clients with that as well. And I wanted to bring that to your attention that it's expired, but people may still be trying to take advantage of those because they didn't receive them when they were due to them. So this is a real convoluted slide, and if you can't see it very well, you can go on the Kentucky Career Center's website and sort of follow it along. At the bottom in this gray area, it has the formal definitions of all of the different types of unemployment that I just discussed. And then it has the different types of claimants, the different steps in the process they might be in. And then it has the flow chart of how they can receive benefits. So I thought this was a really useful slide and information, but I know it's might be hard to see and difficult to navigate. So if you look it up on your own, I would go to the Kentucky Career Center website and see where you or your client fall within this flow chart to see where they might need to go for help. So mostly how to apply for unemployment, you apply online. There is a way to apply over the phone. I think we know sort of anecdotally, people are having a really hard time accessing anyone over the phone. So that online claim is definitely the way to go. You're going to want to have all of your contact information, date of birth, social security number, employer information, and places where you worked. You're going to need that information handy because your work history is very important to your claim and your eligibility for unemployment. This is just an online sort of screenshot of what the Kentucky Career Center page looks like and what you'll be looking at when you or your client need to file for unemployment benefits. This is this page that you'll be navigating. There's a lot of phone numbers out there relating to unemployment. This is just one of them. This first one, how to help someone troubleshoot. Again, that kentuckycareercenter.ky.gov. You can schedule in-person appointments for help. The appointments go really quickly. So you'll want to follow this website right here in order to schedule an in-person appointment for help with your claim. If you contact your local legal aid office, the legal aid attorneys and staff may be able to help you troubleshoot your UI claim, or instead of going through on your own, they also have representatives who are able to give their attorneys and staff help a little bit faster to process claims and a little bit faster advice. And that could help you or your clients process their claim and get their benefits a little faster if they're having issues. So contacting a legal aid office, again, you're not necessarily signing up for a lawsuit, for example, but using that sort of extra liaison help that's been made available to our legal aid programs could help someone move their claim up along the line rather than them just staying on the phone all day or and not getting anywhere, for example. When we talk about sometimes when you go through the process and you receive a notice of determination, you might be denied unemployment benefits, and that notice that you or your client would receive would be what's called a notice of determination. So the notice of determination is your sort of your legal notice of whether or not you qualify for benefits. On that letter is a paragraph that states your appeal rights. It usually says you have 7 days to appeal, and we actually have it. I don't know if you can see it very well, but it is a version of that is at the bottom of our screen here, of this slide here. When you appeal, it has to be in writing. It can be emailed, it can be faxed, it can be mailed with paper. You're going to want to include your name, the last 4 digits of your social security number, any sort of reference number or claim number that you have, and your regular contact information. There's a separate UI appeals branch, and there's a whole separate system out when claims are appealed. And the appeal would go to first the hearing officer. It could be appealed in front of the whole commission, and then eventually could even be appealed to a court if you have someone who has repeated denials and legal issues that they want to raise with their claim. There are several different avenues for appeal and several different ways up the chain that someone can go in terms of appealing these benefits. So keep that in mind. It's not over, but there is a time limitation from the time you get their notice of determination to file a timely appeal, because your appeals do have to be timely. So keep that in mind as you're advising people on what to do about unemployment.
So to summarize the different issues in the workplace that we've talked about and how people can get help with those problems, this slide just gives some basic information on where to go for what, kind of summarizing it all. So for minimum wage and overtime issues, those can be reported. Workers can report those to the Kentucky Labor Cabinet or United States Department of Labor. Health and safety issues can be reported to Kentucky OSHA. And workers' compensation, for that, you would need a private attorney. For discrimination, in Kentucky, we have the Kentucky Commission on Human Rights. There's also the Federal Equal Employment Opportunity Commission and the specific commissions for human rights or civil rights in Lexington and Louisville. we have our own agencies as well if the employer and workplace is located in those areas. And then for misclassification, we recommend getting a private attorney. And what we can help with are these things. We can help with those wage and overtime complaints, and with the first step of submitting a demand letter to an employer. So those are our phone numbers and contact information for our Lexington and Louisville wage claim clinics. And for Lexington, we can help somebody anywhere in Kentucky, not just Lexington. And then for other issues such as retaliation or labor trafficking, that is stuff that McKinsey may be able to help with as our employment law attorney. So that is our last slide, and that summarizes our information about workplace issues and workers' rights in the workplace. So thank you for tuning in to this presentation, and hope you enjoy the rest of the Kentucky Refugee and Immigrant Inclusion Summit.